Hello, my name is Heather Zelle, and I'm going to talk today about advanced directives for mental health care. I'll jump right in and ask some important questions about treatment decision making, especially treatment decision making during a health crisis. So, what if you needed health care but you were not able to make an informed decision about your care? And that could be for any reason, any sort of thing that's interrupting your thinking about your health care and your ability to make decisions. What happens then? Someone's going to have to make decisions for you when you cannot make them for yourself, particularly if it's a treatment that needs to happen sooner rather than later. And so there's the question is, how can you control who that someone will be and what decisions they will make? And of course, the answer, as you might guess from the subject of the talk, is to write an advance directive. And I'll take a second now just to note that while I'll talk about advance directives for mental health care today, truly everything I'm going to talk about with regard to advance directives in Virginia applies to anything, any type of healthcare advance directive you want to make. I'll explain a little bit more about why that is in a few slides, but I just want to encourage everybody who's watching this, thinking about this, to consider making one for yourself, whatever your healthcare needs are, whatever your age is. It's just good practice to kind of think ahead. Hopefully none of us ever need to use our advance directives, but then if we did, they'd be there and ready to help guide our care when we can't do it ourselves. So let's jump right in. What is an advance directive? Let's get the definition right off the bat here. So an advance directive, it is a legal document. That's one of the core things about it in terms of its characteristics. It's about directing future health care. It's not about signing away, the decision-making ability now in the present. It's about setting up directions for the future. And that future and whether it gets turned on is defined by whether you become incapable of making an informed decision about your care. It's not, again, it's not like set to some particular timeline or anything like that. It is there to come in when you can't make those decisions, to kind of be your voice, pre-recorded voice that it can speak for you and help guide your care. And so there's really two basic things that you can accomplish with an advance directive. It sounds like a big term. It can sound like a technical sort of thing and maybe sort of intimidating, but really it's pretty basic. It's just a legal tool that you can use to direct your care in advance. And there's two basic ways that we as people can direct our care in advance. We can appoint a healthcare agent. Otherwise, sort of the older terminology, it's sort of changing. It depends on, what state you're in, but a healthcare power of attorney is the same idea. The other thing we can do is give instructions about our care. And with an advance directive, you can do either of those, or you can do both. It's really up to you how you want to use it, but it does allow you to do a range of things. And the reason, this is something else that I like to just kind of put out there to have, so we all have it in the back of our minds moving forward, is just the reason we're doing this, we're planning in advance, is because our decision making, our ability to make decisions for ourselves is fluid. It is something that can change. And an advance directive really fits well to this idea because the advance directive is something that's built to turn on and off, as opposed to some other treatment decision kind of mechanisms that are out there, which once they're turned on, they can be hard to turn off, or they might take a little too long to turn on in the midst of an emergency, those types of things. So recognizing that our thinking, our ability to make our decisions is fluid, is part of what this is all about, kind of planning for that time that maybe we aren't able to make decisions. And so at base, decision-making capacity, the way it's defined in the law and what a provider is going to look for is basically, can you take in and understand information about the treatment options? Are you able to make decisions, kind of rationally weigh things out? And are you able to communicate that decision consistently? So those are the sort of base, parts of the idea of decision-making capacity. And again, we're talking about this because it's something that can change, and it's also something that isn't necessarily global, right? I could have the capacity to make some decisions, but maybe there are some others that are just too complicated for whatever is kind of going on with me at that moment, where it would be more appropriate that somebody else make the decision for me. And as I've already mentioned, right, we can lose and regain our capacity to make a decision as well. So it's really something that you kind of need to look at moment, to moment, decision by decision, and not just assume that once, somebody's been determined not to be able to make a decision, just don't assume that they'll never be able to again. There may be other decisions that they can make right now. There may be other decisions that they'll be able to make again in the future. So I like to put advanced directives in the context of advanced care planning generally, since there's all of these different tools that are out there, and I'm sure many of you are familiar with at least one of these that I have listed here. And so the advanced directive is like a cousin. They're all cousins to one another, I guess you could say. Two of these, the healthcare power of attorney and the living will, have some similarities historically, and at base, the thing that makes them of the same type is that they are legal. They are legal documents. They have a legal authority because, the state law says that you can do these things and whatnot. A do not resuscitate order or a physician order for scope of treatment, those are things that carry authority because they have been signed off on by a physician. Those are things that don't become sort of controlling and valid unless the form is filled out and signed off on by a physician. So those are also have authority, but from sort of a different source. And then there's crisis plans, just to use a sort of generic term, which are absolutely advanced care planning tools as well. And while they don't have the authority in the sense of being a legal document or a physician's order, they are immensely valuable because they are authored by the person themselves, and can just be such a wealth of information and should certainly guide decisions, even if, and this is a little bit my opinion, but even if the law, doesn't say so. So crisis plans, advanced directives are related to all of these, and they just kind of provide another option, another approach to how you might put your decisions down on paper and have them ready for loved ones, for decision makers, for providers. So I sometimes talk about the legal evolution. I think I won't spend too much time on it today. I'll just note that these are the legal tools, the advanced directive, and its forebearers, the living will and powers of attorney. Those come to us from state laws and eventually federal law. And by 1990, there was sort of a federal understanding that just about all the states had something on the books that allowed for folks to make something like a living will, end of life care directions, or or to have a power of attorney for healthcare decisions. And so the states were doing that. By 1990, we get a federal law that kind of supports that. Just generally speaking, it was in the 1990s and later that advocates and some state laws eventually recognized that advanced directives up until then had been focused on end-of-life care, then maybe a bit on other medical care, and sort of recognized, hey, we can capitalize on the benefits of advanced care planning in the context of mental health care with this idea of an advanced directive too. And, the part of the, why is this capitalizing on things? Why is this, such a great use of a tool like this? That's because effective self-management is going to require two kinds of expertise. And, again, self-management in terms of any sort of healthcare, you need the medical expertise of healthcare providers, and then also expertise of the person themselves, who is going to know about their treatment and their goals and culture and values better than anybody. So we'll boil this all down then. What does this mean for advanced directives in terms of what they are? Just sort of our quick recap. Advanced directives take the idea of a healthcare power of attorney, where you're picking somebody who will have the legal authority to make decisions for you when you can't. And it's putting that together with the idea of a living will or other sort of advance instructions that you're giving that will direct what can and cannot be done in the future if there's a time you can't say for yourself. And those are going together in the idea of advance directives. So it's a new name for sort of the evolution of where we got to with the legal tools that were developed. And then because we're in Virginia, we need to think about what goes into that and if there's anything specific about that. So generally, we think about advance directives having end-of-life care and general health care. In Virginia, we are, as far as we know, the only state so far that's done this has very thoughtfully, intentionally indicated that mental health care can go in the exact same document. So a lot of times we'll hear about maybe a psychiatric advance directive, which absolutely is a thing, but I just want to note that in Virginia, our advance directives they don't have to be specific like that. So you don't have to have one for all of your other healthcare and sort of a separate thing called a psychiatric advance directive or a PAD. You can have just one document because you're one person and you've got, one set of health care things that you want to cover. So I will probably, throughout this talk in terms of just advance directives without specifying mental health care or psychiatric. And that's because we have this, more general idea about using advance directives to plan in advance for healthcare, regardless of what it is you want to put down. So at this point, kind of walking through real quick, getting a lot of hopefully the vocabulary down and those types of things. I do need to pause though and make the important caveat that recognizing my audience, make the important caveat that these are legal documents like contracts, and so they are in Virginia. And I believe in other states, but I can certainly speak to Virginia. These are going to be available as legally binding documents only for adults, just like only adults can sign off on contracts or things like that. That an advance directive, a legally binding one, can't be sort of signed off on by a youth or an adolescent. However, I still think that this is a great topic for us to be talking about, you to be learning about, even if a good portion of the audience are under 18, because there's still excellent tools. The forms that are out there can be a great template for you to walk through with your loved ones, and ask some of the questions and write up a plan. Just because it's not signed off on at the end and it doesn't have that legally controlling authority, it doesn't mean you can't use it as a way to have the discussions and get some of those details down so that you have them if you need them. And then once a person turns 18, then you can go ahead and get it signed, and it will now be a legally binding advance directive as well. And so, I noted that crisis plans are something that may be, part of somebody's, toolbox as well. And advance directives really relate well to crisis plans or RAP plans or other, more specific models of a crisis plan. But one thing I'll just point out in terms of why it's worth doing both is that an advance directive tends to be very pointed and succinct in ways that will maybe benefit in a medical care setting, in a setting where it's helpful sometimes to have a standardized form where a provider can flip through it, see things in the terms, and look for the parts that are kind of in the terms that they need, and all of that for those, especially if it's sort of things are moving quickly. And so I think it is worth doing both, in my opinion. But I do want to recognize, you may have already used other tools to have these conversations and to record some of your plans and treatment decisions. So, but I'll still suggest you consider an advance directive as well. It's helpful kind of complement to a crisis plan. So just to sort of briefly give a sense of healthcare advance directives, what we kind of think about them if we do. They certainly cover a fair number of things. Picking a healthcare surrogate or an agent. The treatment instructions. This can include more than just end of life care instructions, but we all still, I think, there's a lot of pool to still think in terms of the end of life care version of an advance directive, or a living will, as we call them. But you can, cover other medical care items, and you can make notes about organ donation wishes, and then, you'd have the signatures and things like that that are needed. When an advance directive that has mental health instructions can, takes that and then adds a whole lot to it to really make it, to capitalize again on that advanced care planning for capitalize it on in a mental health instruction setting. So, all sorts of things can go in, like facility preferences, emergency contacts. So that would be maybe, other than just call my agent, but also, here are a couple key people who they might not be the decision makers, but they really need to know, or I want them to know. If I'm in the hospital, instructions for hospital staff, crisis symptoms, relapse risk factors, protective factors, electroconvulsive therapy preferences, and instructions even can go in there, since that is a pretty specific treatment some folks have strong feelings about. And then, just a host of medical information that, might be related to your care and your needs and what works for you. So it can really be quite rich in terms of, sort of like a little cliff notes, or sort of here's a brief little summary to my healthcare providers who maybe haven't had a chance to get to know me before now, of some of the key things that would really maybe help us all get through this a bit quicker. Because I'm a bit of a researcher myself, I can't not tell you a little bit about the research. This is just some highlights, that it's not just sort of a good idea in theory, actually have seen some benefits. And so these are a couple of studies that have been done over the years that have shown the benefits of filling these out in terms of having an increased sense of control, improved working alliance with providers. This all kind of makes sense, right? If we're just communicating more, this is a way around which to communicate. I think an important one to highlight too is having medication preferences in an advance directive increase the likelihood that the person would receive that medication instead of an alternative, which then increases the likelihood of staying on medication and reducing symptoms. It just sort of, instead of, falling into a guess and test, or this is the usual plan A we go with, but you already know that plan B is really what works best for you. It's a chance to kind of, say that right off the bat, and have things hopefully move more smoothly forward, instead of having to kind of, retrod old ground, getting back to where things work best for you. One important study looked at the impact that advance directives with mental health care instructions have in terms of coercive intervention. So they followed folks for 2 years to see if there was an impact on folks having or ending up experiencing or having, used on them police transport, involuntary commitment, seclusions and restraints, involuntary medications, all of those types of things. And over those 2 years, the folks, they had two groups, one that filled out ADs and one that didn't. The folks with advanced directives were half as likely to experience those coercive interventions. So it's huge to kind of cut something in half like that. So really important to know that it's not just this, warm, fuzzy, feel good. It's nice we filled this out, but they actually can have great impact on some pretty important areas of treatment and in emergency situations. Also like to talk to the clinicians, right? Make sure that they know too that that advanced directives for mental health care are useful. There's sometimes that a myth or a worry that somebody is going to use this to just say no to everything or something like that. And so studies have looked at that too, and they have been rated, by a psychiatrist or whomever, as including useful instructions. As I think maybe, again, thinking of my audience, you all would know that you have useful things to say and to put into these, but just to make clear and to kind of combat that myth, folks are putting useful instructions in. It's things that are in line with clinical practice standards. It's that thing of like, look, there's a plan A that you usually go with, drug, whatever. And then, you go with this other drug as a plan B. Well, let me just tell you that plan B, that drug is the one to start with for me. I can already rule out plan A for you, that kind of thing, where it's speaking in terms that are right on, in line with what the providers would need. No one in these studies used an advance directive to reject all treatment. Everyone authorized hospitalization or a feasible alternative. And so again, just that sense of these aren't being used, to kind of block care in a way that just helps nobody. And then this is related to that earlier, this is that same study, but kind of putting the emphasis, on the physician here, and just in terms of like having the information about medication refusal and preferences leads to, those being followed, more quickly, instead of going through sort of the guess and test or the, plan A before we even get to plan B. And it kind of makes sense even in just a basic way of if you think about going into your doctor's office and if your doctor said, I want you to start taking this blood pressure medication, and you just said no, that's probably not where the conversation would end. You'd probably say no because. And so in an advance directive, you're able to say no, but it also kind of prompts you and gives you a space to say why, which is very helpful to a provider to hear the why, as well as the no. So question, can adults with mental illnesses make valid advance directives? Yes, of course. That's why we're here talking about this today. But I'd like to point out that it's both legal and practical. And what I mean by that is in Virginia law, they have been very clear about saying every adult, and again, recognizing we're talking about adults at this point, every adult is presumed to have capacity to make treatment decisions on an advance directive. Having a mental health diagnosis does not by itself change that. In some states that have a psychiatric advance directive, they might have like an extra step where somebody has to go have it signed off on by a doctor that has to say, yes, I checked and this person is well and able to do this right now. Virginia in the law, says it doesn't matter what diagnoses are listed in whatever record. We're going to start from the presumption that you are able to make these decisions and can do so on a piece of paper if you want. And again, just that sense of clinicians are rating these as clinically appropriate and helpful. So that's where I mean, yes, practically. It's a really useful way of communicating. It's not something that is being used in a way to obstruct or otherwise kind of just slow things down or something like that. Nope, these are helpful little instruction manuals of sorts. So let's talk about a little bit more about some of the specifics in Virginia. Given the time today, I won't go into all of the, what you can put into an advance directive in Virginia. But it's kind of easy actually to do this part in terms of what the legal requirements are, because one, we've already talked about an adult is going to be presumed to have capacity, unless, I guess I should have said on the previous slide, unless they're already sort of been legally or clinically found to lack capacity. But that when it's like clearly that situation, we're saying no. But otherwise, if you are an adult who doesn't have one or both of those sorts of holdings or findings already in place, then we're presuming that you're able to make decisions about your healthcare. So in addition to that, all you need is to have the paper signed by yourself in the presence of 2 adult witnesses. That is it. Virginia made changes to its laws about 10 years ago now to make it sort of that easy in terms of the, uh, bits and pieces of paperwork and getting, signatures. They didn't want that to be a barrier, this idea of having to maybe have an attorney involved or to have it notarized or to have it be on a specific form. Those things are really just barriers at the end of the day. And on balance, Virginia was more interested in having the doors wide open so that people can access and make these than having a bunch of, you know, I guess safeguards in place, but that are really more often than not maybe just kind of hurdles that keep people from getting this done. Even when they really want to, if it might even just be the matter of like, I don't have time to go to the notary or something like that. I think it's also worth this may seem like a funny little thing to note, but photocopies are valid. And I point that out just because sometimes it really matters with legal documents that you have a copy with an original signature. That's not the case here because, again, the idea is we want these to be available and to, we want it to be able to be circulated. And so if you fax a copy or you make copies to give to somebody, to your loved ones so that they can bring it to the attention of a provider, like you don't have to sign 15 different copies. So it's and the idea of it being scanned into an electronic health record or things like that, that is fine. Nobody should be asking for the original copy with the original signatures or demanding that is the only one that's legal. So again, we could spend quite a while going through forms and parts of forms. And I don't want to go down that rabbit hole, but I'll just point you in the direction of what I hope are helpful. Some work that we did a few years ago was to try and take the idea of the form in Virginia and make a user-friendly template, one that avoids legalese, one that has helpful instructions right alongside, so that gray bar on the left is just sort of provides information and helps you know what this section is about or whatever. That is right there alongside of each part for which you might want that info. And we really tried to get the language such that it's like, the way we all speak in sort of everyday language instead of legalese, so that it's easier to understand and it's clearer what you're saying and those types of things. So that form and related ones, we made different versions of it, some that are specific if you wanted to do one just for end-of-life care, or just for medical care, or only for mental health care. We have different versions of it on that website, virginiaadvancedirectives.org, as well as information to help you pick out which one might be the best fit for you. So we think these are pretty good forms. There's certainly others out there. And again, you don't need to use a particular one. So whatever you find that seems to work for you, go with it. Let's talk about a couple of the ways that an advance directive works. Some of the, I guess, most important things to note. Thinking back to how I said this is something that turns on and off. That's part of what sets it apart from something like guardianship. Advance directives are much more fluid, just like capacity is fluid. They're kind of meant to be something that turns on and off with, sort of an easiness. So in Virginia, it takes 2 physicians or 1 physician and a licensed clinical psychologist, and both of those providers have evaluated the person and determined that the person isn't able to make decisions about their health care right now. And if once those evaluations are done, it's documented, the person is informed of this, then the advance directive is turned on. It's now in effect and has control in terms of if there's a healthcare agent, that person is now sort of activated and in charge of making decisions, and the instructions are binding and those types of things. We want to make sure that we don't want it to just be a single provider to it's helpful to have that kind of review person who gives a second opinion for turning it on, because we are at that point taking away decision-making power from you for a little while at least. But we do want it to be easier to get the decision-making power back to you. And so it only takes one physician to if one physician finds that the person is able to make the informed decisions again, then the advance directive turns off and it goes back and on the shelf, and it's there if it's needed in the future. But that's sort of its job. It doesn't, get destroyed or thrown out. It just goes quietly back on the shelf in case it's needed again in the future. There's an option in Virginia that was added a couple of years ago. For some folks, you might be thinking, well, in an emergency, in particular in a mental health emergency, where it really might just be the best, what might be best is to sort of expedite the process of getting the person, they meet hospitalization criteria, and it would just be helpful to have that move forward instead of having things drawn out and lots of time passing. And so in Virginia, you can choose in your advance directive for your agent to be able to consent to psychiatric hospitalization. They're not deciding that you meet hospitalization criteria. It's just if the provider says, if the physician, the doctor says, we think that Heather meets the civil commitment criteria and hospitalization is really what we just need to do at this moment, then my agent would be able to say yes or no on my behalf. And this power can be turned on based on just one provider if you want it to be so. If you'd still rather have that power turned on only on the basis of two physicians or a physician and a clinical psychologist, that's fine. But did want to put the option in there if you kind of know from your own history and you just want your agent to be able to get in there and make that decision so that it doesn't get into lots of the legal decision making and court orders and things like that. You can say just one provider who evaluates me about this this particular decision. That's all it takes for that power to be turned on and my agent to be able to speak for me. And so with that idea, that general aim is to expedite that process of in a mental health emergency. So that's why we have, instead of two providers, just one. And the list of providers who can make that evaluation is expanded. So it's not just physician and clinical psychologists, also a psychiatric nurse practitioner, licensed clinical social worker, or a designee of the local community services board. That's the language from the law, and basically that's referring to emergency services pre-screeners from the CSBs for, in most cases, as far as I'm aware. I think it's important to note, once I am admitted, everything else is still turns on that idea of two physicians or a physician and a psychologist finding that I can't make the decisions, and that turns on the advance directive for the rest of the decision making. So another important power or specific thing that you can do with your Virginia Advance Directive, and I should have maybe not had the text come all up at once, because this is another one that just takes a minute to wrap your mind around. But you can also use your Advance Directive to plan ahead if you're worried that you might say no to treatment while you're unable to make decisions. If there's a head injury, if there is something going on with your thinking where you are conscious and able to sort of, take part in the conversation, but you are not making the connections and the decisions you would outside of the emergency, you might be worried that, you would object to something and everybody would have to listen, because when you object to something, healthcare related, that really does hit pause on the clock. It really kind of is a timeout. Even if you have an advance directive that says, here's my agent, etc., here are my instructions, when you present an objection in that moment, out of an abundance of caution, don't want to just steamroll right over that objection. And so typically, you could set up your advance directive and have all the instructions, but if you were to then object, it would kind of derail things for a little bit of time at least while trying to find out, can we get another source of authority to make sure that it's okay? We are going to proceed in this manner. It might take more time, maybe going and getting a treatment order from a judge or something like that. Here, you can kind of, again, expedite or kind of plan ahead for that so that there isn't a big hang up in your treatment. And so this is the chance to give the agent the power to authorize treatment even over your objection. And the way it's set up in the form that I'm kind of that I pointed you to on the previous slide and elsewhere, but it's particularly clear on that form, I think. The sort of guidance about how to present this in the advance directive does make very clear that you might want to be specific. There might be some things you always want to be able to object to. You might have a very specific thought on this topic when it comes to admission to a mental health care facility, those types of things. So you can get in, it doesn't have to be a blanket sort of like, you can always ignore me. And it really is up to you and, what you feel about your care, what you worry about for an emergency situation, how you feel, it would be best to outline this situation for your agent. I often share, the fact that in my advance directive, my agent is my mother. And it's not just because she's my mother that she's my primary agent, the first person I ask people to call. It's because she's a retired nurse and she really knows, a lot of the healthcare stuff that needs to be, known about. And so she could maybe make the decisions better than me today, just because she has that knowledge and experience. And so I am sort of in a place where, I have a good relationship with her and I have that trust in her training and skills and knowledge, that I sort of said, if there comes a time that I'm in this sort of situation, yes, please just follow whatever she's saying. Even if I'm objecting, I'm going to trust that she will be able to make the right call, which could include her hearing me object and thinking, I think maybe, we shouldn't go with this option. It doesn't mean that the agent will always act over the objection. It's just trying to make it clear that they have the authority to do so or not. Of course, objections about end-of-life care are always going to be honored. Just important to point that out in terms of if you had instructions saying to remove, some of the different, care and different things, but in that moment you kind of come to enough and object or something like that, they're not going to just sort of go ahead with those. That will always kind of slow down and be thoughtfully plotted through. This acting over objection here is about these sort of non-end-of-life care situations. This is just a quick screenshot of sort of how it's set up on that form I was mentioning. Again, it has the gray bar on the left with some instructions or guidance, and then you can see how it kind of breaks out to make clear, whether the agent does have the ability to act over your objection to admission at a mental health facility. And then you could go on and say, more specific things. My agent does not have authority to consent to. So really can, and just because there isn't a blank for something in the form, again, you can always add more. We tried to make the forms, sort of generalizable and have space for what we thought a lot of folks may or might be thinking about putting down. But if you need to add a page, sort of thing. It's one of the nice side effects of not having to use a certain form. You can really tailor the form to include what you want it to. I noted earlier that you only need a couple of signatures for an advance directive to be legally binding. When it comes to this particular power, however, it's a pretty big deal. And so this is one place where the Virginia laws are set up to require that you meet with your doctor or one of these other, sort of providers here and just, tell them why you're doing, tell them that you're doing it, that you get what it does. You don't even have to tell them like all the whys, but more so it's just a check because it's a pretty big deal. It's a big power to be giving. And it's a little confusing to think about sometimes. So it's sort of an extra check to make sure that, yep, you totally got it. If you did decide to give this power, you know what you're doing. So one last part I wanted to mention about advanced directives before talking about a couple of the alternatives to advanced directives that make, my case for why you should think about making an advanced directive. I did want to just touch briefly on the agent. I've been mentioning this person, and I just want to underscore again that person is, you know, legally authorized. This is somebody who has authority under the law. And so healthcare power of attorney, if that sort of, language is familiar and makes that sort of stick better. But there's more to it than just, being the person, written on the form. It really is somebody that ideally, you've picked because you trust them, not just generally, but to advocate on your behalf, to carry out your wishes. They are aware of, and, your agent in Virginia doesn't have to sign off. So you could write someone down without, and you really want to check with them before, because they can quit. Because we don't want to force anybody to make decisions if they feel like that is not the right, they're not the right person, they're not equipped, or whatever it is. So it really, you should be talking with this person anyway ahead of time and not surprising them with it. But it really is, it can be a particular person and a very, specific person, and maybe not the first one that would come to mind to somebody else who's taking a guess. It's sort of just convenient that mine is my mother, is, a parent is maybe somebody that might be guessed, by a lot of folks in a generic sort of way. But it's not always that, person or that maybe comes to mind first. So it is a chance to be very specific about that person, and that person has this, legal authority. So you really want them to be prepared in terms of, you've given them the advance directives, so they have documentation of your, instructions and wishes, your values, and have, talk with them about it. But other than that, or other than the criteria that you put on the person, the law doesn't put very specific criteria. It doesn't do much picking for you. It says it needs to be an adult who is able to make decisions. That's as far as the law goes in trying to pick this person for you in your advance directive. And so it really leaves the criteria up to you, and gives you a chance to pick somebody that you've thought about and talked with and all of these types of things, instead of some of the alternatives that we'll be talking about in just a minute that are a little bit more one size fits all. And as an agent, that person does need to know it's not just about, having your best interests at heart. They have to follow your instructions and preferences. They are signing up to follow what you've set out in your advance directive. It's not sort of a sense of what they think is in your best interest, or they kind of guess and put themselves in your shoes. It's like, no, if there is something written down or that you've otherwise, communicated to them, that's their instruction. That's what should guide their thinking. If it's something that's more in line of a preference, it's not as strong as an instruction, but it's a preference, like that should help them figure out whether A, B, or C is the right option for you. It really should be, sort of the playbook for them. Okay, so I know I've been moving pretty quickly. And so I'm going to take a breath for a second and just chit chat here and note. I'm looking forward to any questions. I believe I'm signed up for the 10 to 11 time slot on May 1st. And I'm always happy to talk about this subject. There's just so much, that we can talk about, and I hope I hit some helpful high points today. Um, and so these last few minutes, I wanted to put advanced directives in context of some of the other things that the law has, when it comes to other mechanisms that the law has set up for having somebody be in charge of decision making about healthcare. And so there are other laws, and then there's also regulations. I'm also happy to talk about the difference between laws and regulations if anybody ever wants to, but that is certainly not what we need to talk about today. But yes, so there are laws and regulations that set up, who can be chosen and have the authority to make treatment decisions. And so, other generic terms you sometimes hear might be a substitute decision maker or a surrogate decision maker, or just surrogate sometimes is kind of the shorthand that gets used. And so, in short, there are three other places that a healthcare decision maker might, be picked under, or be the authority might be granted to somebody else based on these other areas of the law and regulations. So the Healthcare Decisions Act, I don't think I've mentioned until now, that's the name of the act in Virginia under which it says we can make advance directives. So the Healthcare Decisions Act is where we get all of the details about advance directives in Virginia. It also provides an alternative for when there isn't an advance directive. So we'll talk about that. Authorized representative is something that the regulations provide as another alternative. And then, of course, there's guardianship as well, which is in a different section of the law altogether. So I tend to call these one-size-fits-all lists. It's statutory. It's in the Healthcare Decisions Act law in the case of this first list here. And this is it's just the list. It's one size fits all in terms of, if I was the provider and I'm like, oh, shoot, this person isn't able to make decisions, I need to find somebody. Where do I start? The idea is that you go down this list. If there's already a court-appointed guardian, that person already is the one with authority, so that's where you go. But if that's not the case, then you start, does this person have a spouse? Does this person have adult children? Fun fact, in Virginia, majority rules when it comes to children or siblings, and so it's not a matter of like the oldest wins the argument or something like that. So if you have an even number of siblings or children who are weighing in, you could have a tie and about which way to go with the decision, and it can kind of get a little bit difficult. But in any event, kind of go down the list in this order. Trying to get a hold of somebody, and of course time is part of all of this too, and so it's not that you have to spend a day trying to find a spouse before it's moving pretty rapidly, but this is the idea and sort of a priority sense of who to try and start with instead of jumping down near the end of the list. So an authorized representative is it's something that comes to us from the regulations, and so it is a mechanism that will allow somebody to be, have the authority to make decisions, but it has limits to it that a Healthcare Decision Act surrogate doesn't, and then a guardian doesn't. Again, there's a sense of, first, if there is a power of attorney, if there is a healthcare agent, if there is a legal guardian, that's who you go to. You don't go find a family member, another, somebody else as the authorized representative. But if somebody like that, one of those types of surrogates isn't available, then you go to the default list. And this is putting the two default lists side by side because they're pretty much identical in most ways. So the authorized representative regulation does note first that if the person has named a family member as being preferred, that should start there. So it's a little different, but then it does go spouse, adult children, parent, adult siblings, other relatives, next friend. And so, and then maybe you go on to finding a guardian if none of those are available. So, not a bad place if you're just guessing and you don't know somebody. It's kind of where we tend to start our thinking, going in this kind of order down a list of family members, but that may not be the right order for somebody, and that's where advanced directives have a real benefit because you can pick um, a primary agent. You can pick then somebody who's a backup in case the primary isn't available or it quits, and you can pick a third runner-up, sort of thing, and it doesn't have to be in the order that you might expect. If it's in my case, I actually want folks to skip over my dad, not because I don't think he'd be a good agent, but it's more so because one, he and my mom are often together, so if she's not available, they're both retired now, and if she's not available, he may not be available either. And also then my brother, thankfully in my case, I think my brother would be a pretty good agent. We talked about it, and so he was game. My sister, on the other hand, is not. She is on my contact list, but I haven't signed her up to be an agent because I know it would be very difficult, if not impossible, for her based on conversations we've had. So I want her to be there and support me, but I don't want to make her be the decision maker. So I kind of really tailored it. It is, family members in my case, in roughly the order that the list has, but it's tailored a little bit more to me, and for others there may be, an even more interesting, sort of rundown of folks to a point. So the idea of, an authorized representative or any of these, again, it's coming on a finding of the person not being able to make decisions, lacking capacity. And so earlier we mentioned how with advanced directives, it's a two-physician or a physician and a licensed clinical psychologist generally. Just for comparison's sake, an authorized representative is going to be an evaluation by a licensed professional, and that list includes physicians, psychologists, professional counselors, clinical social workers, who else? Psychiatric nurse practitioners, and licensed or certified substance abuse treatment practitioners. So it's a wider list. It takes just one. A person or family can seek an independent evaluation, though, so there is a little bit of counterbalance there. But we are, again, it's kind of waiting until that gets done, and then the authorized representative is found. We're kind of on pause, and unless there's an emergency, like it's this treatment needs to, this blood transfusion needs to happen, or Heather is going to very likely pass away, that could maybe go forward, without the substitute consent. But we have to get some of this paperwork and decision making and evaluation done first, which is maybe not as efficient as if there was an advanced directive right there already to hand. I have the administrative code section here if you're interested and want to go see more of the details. One other sort of downside, arguably, I suppose opinions could differ on this, but an authorized representative, their authority is only for decisions made in that facility where the evaluation took place and the care is taking place. So if you then need to be transferred somewhere else, you would maybe have to go through this process again, as opposed to the agent where, once that person is in charge, they remain in charge until you regain capacity, and it kind of can go from facility to facility. So that's a little bit more efficient perhaps too. Okay, so the last point for comparison, the last tool that we're kind of taking a moment to compare is guardianship. And again, this is something that could be its own talk or talks, of course, but to point out a couple of points of comparison to the advanced directive in particular, one thing that's at play here that makes it very different is that the court is deciding capacity. This is not just clinician or clinicians, making sort of this in current time, person is unable to make these treatment decisions. This is a broader look at it, and it's by a legal decider. They're certainly taking information from the providers or whatever, but the ultimate decision is made by the court or the judge, and that capacity. Before, we've been talking about capacity in terms of specific to treatment decision making. When the court starts thinking about capacity here, it's thinking about it in a broader sense. The idea of guardianship, rather, I should say, is sort of set in such that we're thinking about a broader array of decision making. And so it has its own definition here. If you're interested, and again, I put the Virginia Code here if you want to go look up more information. But it's a different decision, maker and this definition than the ones we've been talking about before. And so, as I'm kind of maybe hinting at here, it's maybe not as well suited to medical decision-making capacity that might come and go, depending on, where somebody's health is at. And so it's maybe not a great fit if we're just trying to plan ahead for occasional, time-limited, periods during which I'm unable to make decisions about healthcare specifically. The guardianship tool is maybe too broad for that. And that's based in part on the definition and, who's making the capacity call here. It's also because of how widely or broadly guardianship, the authority that the guardian has, can reach. I think it's worth pointing out, the finding that a person is incapacitated is construed as finding that they are mentally incompetent. So it's taking it further than just inability to make a treatment decision. We're kind of going to a broader sense of legally finding somebody legally unable to make decisions. And so that can end up reaching quite a few rights, quite a few other domains of decision making. So you'll see in here the idea of making a will or advance directive and making treatment decisions are lost, which would maybe be what we needed for that time. But maybe many of these other areas aren't something that we need somebody else in charge of. And so it's reaching very broadly, and it's certainly a tool that needs to be there. But it's part of a continuum, and it's at one kind of end of that continuum, and whereas a lot of folks are probably somewhere in the middle, and it just can be a poor fit. Guardianship can be limited. It can be that the guardianship order maybe gets kind of specific and says, the guardian has control over making treatment decisions and entering contracts and buying and selling and renting property and deciding how to spend money. But some of these other things the guardian doesn't have control over. Like it can get tailored like that. But from our experience, and I mean that in terms of some colleagues I've spoken to who have practiced in Virginia and whatnot, more often than not, guardianships kind of start at the plenary or complete, where it's just sort of the blanket deal, and that's the more common type of guardianship that you see come out of guardianship hearings. And so, these couple of brief, points of comparison that I'm making are focused just to help make that point that guardianship, it should be there on that continuum, but it's really probably not the best fit for many people. And certainly if what we need to plan for is just the potential for treatment decision making to not be capable, for a person not to be capable of treatment decision making for some limited amount of time, then the guardianship is probably going to be your last resort. Try other things first because of how it takes away rights. It's more restrictive than the others. It's not like tailored to this specific situation. Certainly there's stigma involved, right? When we're talking about these kinds of things, getting a court involved and all of this, the terminology alone. And not to mention then, just thinking historically and different, things that we kind of attach to guardianship. It's expensive because it involves court procedures. It is often unnecessary, and that's in the sense of thinking that there's a continuum, and a lot of folks would be better served by something somewhere else along the continuum. And then it's usually permanent in the sense of the burden of having a guardianship ended is on the person themselves once they've regained capacity, and that in itself can be expensive and arduous to go through the courts to do that, and can be kind of fraught. So it can be, if not permanent, much longer lasting than maybe it was needed. Whereas again, the idea of the advance directive kind of can come and go into action is perhaps the better fit. And at least worth trying maybe first, depending on, what you know and what you're trying to anticipate. So that was my whirlwind tour of advanced directives in Virginia, where they kind of sit amongst some of the other advanced care planning tools. Again, as I said, I'm looking forward to some questions. I want to leave us all with the question we started with, and just again, encourage everybody to think about making an advanced directive, or if you already have one, update it. It's great to update them yearly or after any major health event. But yes, we, unfortunately, we all might have something in our future that takes away our decision making. And if we want to, we can plan for that and try and put down at least some information ahead of time. So I encourage y'all to take a look at some of the resources here. Again, there's multiple types of forms on that website, and then you can also have your advanced directive uploaded to, there's a national registry. There's also a Virginia one. The Virginia one is free. And then it can make it, it's one other way to try and make your advanced directive available. It's not something you make and then file away. You want copies in your medical records. You want copies with loved ones and your agent. You want copies out there. And you can also get a copy into the advanced directive registry, which then providers can go look within the registry to go get a copy of it if it isn't already in their records. So lots to think about, I'm sure. Hopefully I've touched on some of the areas you had questions about, but again, I'm looking forward to what questions you bring on the first. And yeah, I think that's it. I should wrap up. I've already gone over, so I hope you all are having a nice day, and I'm looking forward to meeting with you. Thank you.